identify yourself, and then we'd be happy to hear from you, and then we can have some additional discussion. You're welcome.
May it please the board, I'm Willa Hemmons, Law Director of the City of East Cleveland, and I'd like to refer you to the legal opinion. Do you all have copies?
We do.
Okay, good. Okay, I also would like to reserve some of my time for the Deputy Finance Director, Mr. Charles Iaden, if he could be allowed to address you as well.
Okay. Who's that again? I'm sorry.
Charles Iaden.
We'll have him when he comes up. We'll have him.
Okay.
I'll spell it phonetically for now.
Okay, thank you. Okay, I sent a legal opinion to Mayor Gary A. Norton on July 22nd, 2016, and for background, I have set forth that Section 94 of the East Cleveland City Charter as to the council vote reads as follows, and we have it before you, amendments to the charter may, and I've highlighted may, be submitted to the electors by the city by a 4/5 vote, as opposed to what is required when the petitions are signed by a total number of voters of 10%, and that word is shall. So we go down to Section 105 of the East Cleveland City Charter as to legislative procedure, which reads, quote, a majority of all the members elected to the council should constitute a quorum, but a less number may adjourn from day to day and compel the attendance of absent members, etc. Then it says the council shall legislatively act only by ordinance or resolution. The affirmative vote of at least 3 members shall be necessary to adopt any ordinance or resolution, and the vote upon the passage of all ordinances and resolutions shall be taken by yeas or nays. So in my discussion, I say that the words may and shall have distinctively different meanings in legislative interpretation. The word may connotes discretion and choice as to legislative decision-making, whereas the word shall connotes mandatory and compulsory decision-making of legislators. So my conclusion is that Section 105 usurps 94 when it says that any ordinance or resolution can be passed, shall be passed upon the passage by 3 members. And so the charter amendment is any resolution or ordinance. Therefore, it's my contention that with the majority voting to pass, the 3 voting to put the charter amendment on the ballot, then that is sufficient. And the words may and shall are discussed in opinions that you have before you, the Virginia City Board of Education, the Berea College versus Commonwealth of Kentucky, as well as the Hamilton Gas Light case. So discretionary language is secondary to mandatory language such as shall. So therefore, my legal opinion in consideration of Charter Section 94, which is your 6-16, in conjunction with that of Charter Section 105, confers upon council the ability to submit to the electorate an ordinance that amends the charter when 3 out of the 5 councilors vote to do so. As you are aware, we've had several special elections that, of course, are very fragile economically the city, and we have someone who's on your board who's also on our fiscal commission, Mr. Rose, who can attest to that, to successive reductions in our revenue that is generated by the property taxes of the city. And it's put us in a very tenuous position in terms of time after time after time, repeatedly going through special recall elections with an electorate that apparently is not very responsive nor responsible in terms of putting these numerous recall issues forward. And as far as the financial predicament that it has put us in, I would like Mr. Ian at this point to give you further direction.
Before we have Mr.
Yes.
Ian come up, just a couple questions that we may have for you, and I just have a couple. Do you have any case law relevant to charter amendment? The cases that you cited don't appear to be applicable to the specific charter amendment issue, whether or not there's any precatory language, such as you suggested, that might be interpreted in the way you're indicating in the context of a charter amendment.
I don't think there's any precedent with reference to the may versus shall issue in terms of an electoral body putting forth a charter amendment to the electorate. So we've tried to research and shepherdize the various different cases, and these are the closest that we have come up with in terms of the may versus shall. As I said, the charter amendment is any ordinance, and that was passed by a majority as Section 105 is supportive of.
Well, let me just offer a potentially different interpretation and see if, I could read this language as saying that two things. There's two ways that you get to amend the charter. One is by a 4/5 vote of your council, okay, or by a petition with the voters. So, I don't necessarily review the may, necessarily agree with your interpretation of the may language, because it seems like there's only two ways that you can amend, amend the charter, either by a 4/5 vote of the council or the petition by the. So I guess I'm not exactly sure how the may shall language impacts those phrases right there. And so you may amend the charter by a 4/5 vote of your council, or you shall do it by a petition of your voters. So I'm not exactly certain that I would agree with your interpretation, but I'm just one board member, and we certainly would ask any others to, since there's no case law, definitive case law, basically that deals with a specific charter amendment, we kind of have to go by our basic interpretation of the language.
I understand. It's just that discretionary language for me indicates that there's discretion all the way around in terms of, 4/5 may. It doesn't preclude 3/5 being the number that is supported by Section 105, saying any ordinance or resolution. So I'm...
See, I view the may language being may as to how you can amend the charter. You may do it in that way, or you shall do it in another way. I'm not necessarily convinced, but and again, that's just me. And a part of my rationale is you often see in any kind of corporate, even municipal context, but in a corporate context, amendment of the organizational document or the operational document is often requires more than a majority vote, But again, that's just my thinking about it. I don't know if anybody or our law director has any thoughts about it. Brendan, do you want to share, and colleagues, if you want to chime in with your sense as well?
I would. My thought is, I appreciate